Colbert, you raise your right hand. Let's place you under oath.
Yes.
State your full name for the record.
Dawson Tanner Colbert.
So you want to serve 2 years in prison?
No, Your Honor.
Well, you use marijuana. That's what pretty much you're saying is that you want to use drugs while you're on probation. You're going to know you're going to be tested for them. Then that means you particularly want to go into prison and serve 2 years.
At that time, I was off my psych meds, and I am currently getting back on my psych meds. I have appointment actually tomorrow with Centerstone to get back on my medicine and everything.
Well, I understand that may be the situation. What I want you to understand is the significance of even a positive drug screen from this point forward means that you're going to go to prison. So you've got to make a decision. I understand you may have some medical issues and you're dealing with them, so I'm happy to hear that. All right. You understand that you're charged with violation of probation. Do you understand that you would have the right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you had violated your probation?
Yes, Your Honor.
You understand that if we had that hearing, you would have the right to have a lawyer and have one appointed as we've done with a public defender.
Yes, Your Honor.
Do you understand if we had the hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, Your
Do
Honor.
you understand that by pleading guilty, you're waiving your right to a hearing and to an appeal? All I'm going to do is approve what your lawyers worked out.
Yes, Your Honor.
Do you understand that's going to reinstate you to probation, but require you to, in addition to your regular probation requirements, to complete this class that they're talking about?
Yes, Your Honor.
You understand everything I've explained to you?
Yes, Your Honor.
Do you want to plead guilty according to this
Yes, Your
agreement
Honor.
and waive your right to a hearing and to an appeal?
Guilty plea accepted, but with a twist. Dawson gets a second chance, probation plus an MRT class. But here's the kicker. His probation was set to expire tomorrow. The judge extends it for a year. So Dawson's freedom now hinges on a class he hasn't even started. Talk about a cliffhanger.
Yes, Your Honor.
And upon your plea of guilty, I find you guilty, in order that you be revoked to serve your sentence. But by agreement with the state, I'll reinstate you to probation with the additional requirement that you complete this MRT class.
And just as a housekeeping, so he actually expires tomorrow, so he'll need to be extended
It'll be extended for a period of 1 year.
however long it takes him to get this class, effectively.
Well, we'll extend him for 1 year. I think 1 year is the maximum I can extend him. So
Yeah, I believe so.
Maybe two.
I don't know that that's the interest of.
You just want to extend it long to complete these requirements, however long it may be.
we're going to extend you for a year, and if you get the class completed and the state agrees, then you can come back in and have your probation terminated.
Yes, Your Honor.
Can we just give him a May court date then?
That's fine.
Will you give me all the information for the case, guy?
May 25th, May 26th. That'll be the date that you just stay in touch with your lawyer and let them know you've completed the class, and you can come back in on that day and have your probation terminated if you've done everything you're supposed to do.
Yes, Your Honor.
All right.
I'll get it done as soon as I get the information on the class.
Good luck to you.
Yes, sir.
2025 CR 19793, State versus Cheryl L. Doherty. Mr. Lockhart.
I have not seen Andrew Lockhart.
Andrew Lockhart.
We have discussed the case. You had an offer extended. Thanks for getting completed it, but
I'll put it on the second call. (2025) CR 19770, State versus Andrew Eugene Fox.
Judge, I represent Mr. Fox. He just got here. He's got an offer. I haven't spoken with him. If I can just second call him.
Second call. 2025 CR 19683, State versus Teralandis Fritz.
believe, Mr. Fritz, come on up. If we could put this on the 31st, Your Honor. I've done my homework on it as far as the issue with the diversion, but I just need to have a conversation with Mr. Walwin.
I'm standing in for Mr. Wallen. He's out of the country. I don't know whether it's ICE related or not, so he should be back on March 31st.
With or without a mask.
March 31st.
March 30th.
2025 CR 19797, State versus Jeremy Greenwood. Mr. Lockhart, Jake Lockhart.
Mr. Greenwood? I've got an offer, but I haven't heard from him in a while, Your Honor.
You want me to pass it for second call, let you see if you can, before I revoke his bond, or do you want to go ahead and revoke his bond?
I mean, I'm not gonna say I want to revoke his bond, but I tell the
I'm
court,
not asking.
I'm not confident that I can get a hold of him, so.
All right, we have a bond. All right, there'll be a conditional forfeiture of his bond in the amount of $20,000. Facia to the bonding company. The capias for the arrest of the defendant, and we need a date 6 months down the road, which will put us into September. September the 8th will be final forfeiture. New bond will be $100,000. Twenty CR 19041, State versus Roy Kenneth Harris. Mr. Harris, you're here to be arraigned on a charge of violation of probation. You have the right to an attorney. Do you wish to have a lawyer?
No.
You don't want a lawyer, okay. This was basically here because you had not paid your court costs, which is docket number 19041, and you owe $1,120.50. Why haven't you paid that?
Roy Harris owes $1,120.50 in court cost, but claims he's been struggling with transportation and caring for his elderly mom. The judge isn't impressed. Is this a case of genuine hardship or just excuses? And why didn't he pay up sooner? The tension is palpable.
Well, I've been having trouble with transportation and getting to work and things like that. And, I've been helping my mother. She's elderly. I did file a motion to see the judge on April 14th for a reduction in court costs due to all that.
So is it set for April 14th? All right, we'll pass it. Well, first of all, let me arraign you. This alleges that you were placed on probation on or about March 11th, 2024 for the offense of evading arrest, reckless endangerment for a period of 2 years, and that you have violated your probation by failing to pay your court cost balance of $1,120.50. We'll show that you've been arraigned in a plea of not guilty, and we'll set it for that April 14th day for you to have the hearing in front of a different judge about whether or not to relieve you from those obligations. All right, thank you.
Thank you.
Twenty 1917 State versus Dallas, Paul Hatfield. Mr. King.
Yes, Your Honor, that is from pleas.
All right.
Still now, it's present. So,
All right, I've been handed a document indicating that Mr. Hatfield is going to be entering a plea of guilty to attempted child abuse, neglect, or endangerment. It would be a Class E felony, and he'd receive a sentence of 2 years to the State Department of Corrections as a range 1 offender, just with a release eligibility of 30%. He would serve that on supervised probation, complete a parenting class. This would be concurrent to 2024 A640 Davidson County, and his ankle monitor would be relieved, and he would be required to complete an 8-hour anger management class. Does that cover everything?
yes, it does, Your Honor.
All right, Mr. Hatfield, raise your right hand. Let's place you under oath.
I do.
State your full name for the record.
Dallas Paul Hatfield.
Mr. Hatfield, you're here today charged with actually with child abuse and neglect, but I think it's been amended to attempted child abuse, neglect, or endangerment. But have you seen or been shown a copy of those charges? Talked them over with Mr. King, you and he discussed the range of punishment you're facing as well as any possible defenses you might have.
Yes.
Well, it's indicated that you want to enter a plea of guilty. Do you understand that you have a right to plead not guilty and to have a speedy and public trial by jury?
Yes, Your Honor.
Do you understand if we had that trial, you would have the right to have a lawyer and to have one appointed if you could not afford your own?
Yes.
Do you understand if you went to trial, you'd be presumed to be innocent until such time, if ever, the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, Your Honor.
Do you understand that if you went to trial, you and Mr. King could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by the use of a subpoena?
Yes.
Do you understand that trial, you'd be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, Your Honor.
Do you understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, Your Honor.
Do you understand that by pleading guilty, you're waiving your right to a trial and to an appeal? All I'm going to do is approve what your lawyer and the state have agreed upon.
Yes, Your Honor.
Do you understand that's going to result in a conviction? And that conviction will be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime.
Yes, Your Honor.
Do you understand everything I've explained to you?
Yes, Your Honor.
Do you want to plead guilty according to this agreement and waive your right to a trial and to an appeal?
Yes, Your Honor.
Do you understand if you plead guilty, the court of the state could ask you questions about this offense, and if you answer those questions under oath and on the record, and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we determined that you were lying under oath?
Yes, sir.
Is your decision to plead guilty today voluntary?
Yes.
Anybody forcing you to do this against your will?
No, Your Honor.
Do you understand I can't accept your plea unless I'm satisfied you are guilty and there are facts to support it?
Yes, Your Honor.
Then are you in fact guilty of this charge of child endangerment?
Yes, Your Honor.
And tell me what happened.
Dallas Hatfield just admitted to whooping his stepson hard enough to leave a mark. The courtroom falls silent. This isn't just a legal moment, it's a moral one. How do you react to this confession? And will the parenting class and anger management be enough to change him?
Well, I've had my stepson, or not my stepson, the child for a while, and he was opening the door, and I told him multiple times not to, and I whooped his butt on the side of his cheek. He was wearing a pull-up, and about an hour later, when he was playing, he bent over to pick up a toy, and I seen that it left a mark.
All right. General Willoughby, you want to add anything to that?
No, Your Honor, that's pretty much it.
Are you satisfied with your attorney's services?
Yes, Your Honor.
Do you believe that Mr. King has done a good job of representing you competently?
Yes, Your Honor.
Mr. King, you know of any reason he should not enter this plea? Any reason he should not enter this plea?
No, Your Honor.
Then Dallas Paul Hatfield in docket number 2025 CR 19716, upon your plea to the amended charge of attempted child abuse, I find you guilty, sentence you to 2 years in Tennessee Department of Corrections as a range 1 offender and will be suspended to supervised probation. As a condition of your probation, you must complete a parenting course and an 8-hour anger management course.
2 years suspended, probation, parenting classes, and an ankle monitor removed. Dallas gets a second chance, but with a felony on his record. Is justice served, or is this a slap on the wrist for child endangerment? Let us know in the comments. Would you have given him prison time?
And this will be served concurrently to your Davidson County case. You may have the ankle monitor removed immediately. So you'll need to see the probation department.
Thank you, Judge.
Mr. Willoughby?
Yes, Your Honor.
Thank you. Docket number 2026 CR 19843, State versus John Anthony Hodge. King, you represent him? Fine. I'll hand you a copy of this indictment. Do you wish a formal reading of that indictment?
John Anthony Hodge, 19843, pleads not guilty and waives formal reading of the indictment.
Plaintiff not guilty is entered. General, on a date?
It'd be General Hodlin's case, but we can track it with me on 14th of July.
April 14th. July 14th, sorry. July 14th.
So,
That will be for status, July 14th at 9 a.m.
yes, sir. Thank you.
2025 CR 197249 State versus Milton Kirk Hunt. So that's Mr. Vandervoort's case. We heard from Mr. Vandervoort.
I have, Your Honor. We talked about passing that to the 31st. I don't know, actually, I think he texted me, but don't know if he's planning on being here, but that's what we've had in our
All right,
community.
if you've talked with him and the agreement was to pass it to the 31st, we'll put it, then that will be his final plea day.
Mr. Hunt here.
2025 CR 19744 State versus Messiah Aiton Israel.
Good morning, Your
Good morning.
Ms. Crabtree and I are doing that case and we filed some motions. Hey, now I'll meet you in real life. And she is gonna answer those motions, which will get away with the, do away with the bill of particulars request. And then we had a motion to sever, which the state has agreed to.
We set for this afternoon at 1:30, I think.
Yes, but we've resolved it all and we don't want to lose the trial date. She hadn't given me the answer yet, but I've talked to General Sylvia and I think it's going to encompass everything I need to know. And so subject to your honor's approval, if we could agree to that and leave it on the same trial date, please.
You two have agreed on the motions and we'll leave it set for the trial date on March 25th.
Thank you, Your Honor.
Thank you.
And can I address a few
Yes,
more?
before, so I was sorry to hear about your family situation. So-
Thank you very much. I have Rebecca Jobert on the left. You can go, I'm sorry. You can. Rebecca Jobert. The general and I are requesting to move that to the end of March for that sentencing hearing.
So you want to put it on March 31st?
Please, sir.
All right. What was the last name again?
Jobert, Joubert.
Very last page of the
That at
doc.
1:30, and that is correct.
All right, we'll move it to March 31st by agreement.
And one last question, Your Honor. Mr. Harrison is on for a sentencing hearing. That's not until 1:30. We've agreed just to put him on probation. We don't want to have a hearing on that misdemeanor.
What if the judge doesn't agree?
Oh, well, yeah, you can change your mind, but I want to get another body to do that for me, just to do that at 1:30.
Or you can grant a motion for new trial and do it all over.
Oh, no. Well, it was kind of an entertaining trial. It was a free-for-all in the neighborhood.
I remember.
Yes, yes.
So is there any reason to wait till 1:30 or do you have victims coming in?
No, Your Honor.
You do not? Okay, let me see if Mr. Harrison can come in early. If I can't get him here before 1:30, if you'll.
If you need to leave, and we'll just have somebody stand in for you, even if it's Mr. Vaughn.
I'm fine with whatever. So as long as
So you want to leave it at 1:30 to dispose?
Yes, and then
Mr.
that,
Vaughn, we're going to let you stand in for her.
just
But
because,
Mr. Willoughby knows what the agreement is, correct?
yes.
All right. It'll just be an announcement.
yeah, since we're gonna resolve it, I'd rather do that than just keep passing it along. Thank you.
Thank you. All right. Moving to page 5 of the docket, 2026 CR 19851 State versus Marvin Wayne Jock Jr. Mr. Jock, you're here to be arraigned on an indictment charging you with driving under the influence. You have the right to an attorney. Do you wish to have a lawyer represent you?
I have one.
Who is your lawyer?
You representing.
Raise your right hand. Just because you had a lawyer appointed in the lower court doesn't mean you're automatically entitled to one up here. You're only entitled to an attorney to be appointed for you if you have no available means to hire one of your own. That requires me to have you placed under oath and have you fill out an affidavit of your income and expenses
Okay.
for me to determine whether you're classified as what we call indigent, meaning that you have no ability to hire a lawyer. So we're going to give you a form to fill out. Once you fill it out, you will be signing it. And when you sign it, you're making an oath that that is information is true and correct. Lying under that, if you misrepresent it or you lie under it, that's perjury. So you need to make sure it's accurate. Fill it out and then hand it to one of the bailiffs and we'll come back to you. Thank you.
Thank you.
2025 CR 19710, State versus Jonathan Kane Krantz.